Bronkiewicz Law Firm. Your move.
With one of our business partners, we've been discussing recently a somewhat gleeless legal scenario that they found themselves in. And the sole reason for this to happen was because they dared to have some plans for their business future. These plans materialized in conclusion of the agreement, which initially seemed to be a great tool for their business development, but currently turned out to be a grave obstacle, if not a business killer, unless they do something. This contract has been fastidiously analyzed. All the assumptions were taken into consideration. They went after their revenue, cash flow, portfolio of clients. They went even further. They verified the general prospects for their branch of their industry. Everything seemed to be fine. And lo and behold, a small pathogen showed up and turned all these assumptions to be out of date. However, sadly, the contract has been signed, and this posed a legal challenge for them. However, mishaps like war, plague, or volcanic eruption, the latter luckily not in Poland, are everything but new for humanity. Hence, Polish Civil Code provides for a legal instrument to cope with this kind of situation. Please have a look at it. The legal instrument that I refer to is stipulated in Article 357 with the Mark I of Polish Civil Code. Its name originates from Latin and it's called rebus stantibus, which directly translates as if the matters turned out to go this way. Rebus stantibus constitute an exception to the general principle of the law of obligation, continental law of obligation, and this principle, this rule is called pacta sunt servanda. It's also from Latin, and it translates as the agreements are to be obeyed. Yes, definitely they are to be obeyed, but as long as obeyance of the contract stipulates law, not the lawlessness. Because if the circumstances have changed so significantly, the topic, the matter of the contract needs to be altered as well. So when we have a look at what are the premises of applying this legal instrument, here we have it. The first is extraordinary change of circumstances. That's the first issue. If due to an extraordinary change of circumstances, a performance of the obligation entails, here is, excessive difficulties or exposes one of the contracting parties to a grave loss, this is the second, then which the parties did not foresee while executing the contract. And right now we come to the point when we know what the court is allowed to rule. The court may, having considered the parties' interest in accordance with the principle of social life, the court may designate the manner of performance of the obligation, stipulate the value of the consideration, or even decide that the contract shall be dissolved entirely. And when dissolving the contract, the court may, as required as how, decide how accounts between the parties shall be settled according to the principles set forth in the preceding sentence. Okay, so of course, every contract entails a specific risk, a certain risk, but this risk shall not exceed a regular market risk. And in this condition that we have in the market at the moment, definitely pandemic is something that exceeds a regular market risk. rebus stantibus clause has been subject of many rulings by Polish Supreme Court of Justice. And here we have the exemplary one, which is actually pretty recent. It's dated March the 8th, 2018, and it was given in the case number 2 CSK 303/17. So the factual circumstances are not of that importance for us, but what's interesting from our perspective, we can find on page number 7 of the reasons of the ruling is that it's the answer to the question whether a pandemic can be like the reason to apply the aforementioned clause. And what we find here, for the reasons for occurrence of such a state, which is rebus stantibus clause, includes the events of natures like lack of crops, social epidemics, natural disasters, economic crisis of common occurrence. So what we find in here is that the Supreme Court of Justice has named explicitly that epidemics is the premise, is the basis to apply rebus stantibus clause. So when we are already aware of the existence of the legal instruments to be used, the question arises how to do so. Subject to the stipulation that we are discussing the issue on a very general level and legal profession is all about the details, I would recommend to approach the topic in a twofold manner. First and foremost, I would try to renegotiate the contract with the other party. But be no fool, we really should not expect her to sit idle, do nothing, and gladly take over our problem. There is a tough negotiating work to be done. Therefore, simultaneously, I would file an action to the court of law demanding either altering the contract or dissolving it in its entirety, preferably along with the motion to secure our legal position, for example, asking to either suspend or lower the payments. And I believe that this approach should be helpful with coping with this kind of situation. I hope that you found this information of use. Should you have any further questions or doubts, I'm always happy to be of help. Just drop me an email. Please also consider sharing it, as it might be helpful for others. Thank you for your attention. Look after yourselves. Take care. Bye-bye.